Good morning, and thank you for joining me on the Path to Liberty. It's Wednesday, August 26th, 2020. And on this episode, I'm again going to be talking about the Doctrine of Qualified Immunity, this legal fiction created out of thin air by the federal courts and then forced on all the 50 states. A lot of people keep telling me, just like they do on just about anything and everything, well, we got to sue them over this, take them to the federal courts. But if it was created by the federal courts in the first place, I don't know how people think that going to the federal courts to fix a problem created by the federal courts in the first place is ever going to work. So I want to share with you two very recent new examples to explain why this is never going to happen. There's two new cases of qualified immunity that have gone into the federal court system, and they're very similar in how they're approached, but they're in different parts of the court system, and they have the same type of end result. And I think this explanation should show you why this is basically going to happen in almost every situation when you're relying on federal courts to protect you from federal courts. First of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage just got a refresh in the last couple of weeks. I urge you to check it out. It's a lot easier to browse and find all the platforms and different categories and things like that, and I'm going to keep expanding that in the near future. It's 10thamendmentcenter.com/path to liberty, all spelled out. 10thamendmentcenter.com/path to liberty. Find all of the platforms, video, live streaming, archive, plus the audio-only podcast editions. I am very grateful for all the people who've been leaving reviews, either if they're just giving us 5 stars or if they're leaving some actual feedback and comments over on iTunes and elsewhere. It really, really helps us out a lot. And on that show homepage, not only will you find those platforms, but you'll find all of the episodes ever done on this show. Plus, on each individual episode, I include a ton of links. Sometimes there's 2 or 3, but I had a recent one when there were like 15 different reading links, because I want you to be able to go in there. If you find something interesting or if you want to see a source document, you go in and you read it for yourself, because I'm only as reliable as what you can verify what I'm saying anyways. I think I do a pretty good job of being consistent and honest and trustworthy, but I think the more that you actually look at those links, the more that you will trust the information that I'm sharing with you. So I encourage you to do that on your own time. And you can also find our membership program where you can support us financially for as little as $2 a month. That's 10thamendmentcenter.com/path to liberty for all the show info. Again, 10thamendmentcenter.com/path to liberty. Saying a quick hello to everyone out in the live chat. Tyler B says 3 minutes late, but I'm here. And that's part of why I know I get a lot of... The number one complaint I get on this show is that I talk too much at the beginning. Just get right to it, buddy. Why don't you shut up? But the fact of the matter is we're doing a live broadcast. And when you're relying on major social media platforms to send notifications to people, it takes a few minutes for people to show up. So if you ever want to jump through, you want to go maybe 2-3 minutes to start getting into the meat of things. So hi to Tyler, Denver Libertarian. Interest in this episode vis-a-vis the recent legislation in Colorado. I actually covered that, and I will talk about it just briefly, Denver Libertarian. I'm going to briefly mention that later in the show, because I did an entire episode about how, well, not just that the courts aren't going to do it, not that we can't rely on Congress, but there are steps that can be done on a state level. Ula, good to see you over on Facebook. Gary Townsend, Dan Reed, my great friend with the Culinary Libertarian podcast. Lawrence Smith, pro-life, pro-liberty. Justin Morrison. Leslie G. And I saw something else on YouTube that I thought was a good one. Oh, Joshua said early on before the show got started, and hi to Bob Landry as well. Melody. Joshua said, petitioning the federal government to secure our rights in federal court? Who is the one infringing our rights in the first place? I mean, that's really the message that I'm saying here, and I don't think anyone is going to be surprised, but I think the details will be very helpful. And let's get into it here. I want to start out with just referencing this previous episode that I'd done back in June, how federal courts gave us qualified immunity and forced it on all 50 states. And that title in and of itself says so much. Qualified immunity, this doctrine that basically allows government officials to violate people's rights to the point of murdering them and get away with it. In the courts, they are not held to any responsibility by the court system. It was created by the federal court system, made pervasive, and then through the incorporation doctrine of the Bill of Rights, forced on all 50 states. So now, instead of just having a problem in California or in Michigan or in Texas or wherever the problem might be, every time there's a bad opinion by a court, all 50 states get affected. And that's a serious, serious problem. I will link to this episode in the show notes. It's a pretty long one. I forget how long. Maybe it's like 40 minutes, something like that. But I encourage you to check that out to get all the details of the history. I go through the whole history of qualified immunity, and that will be over at 10thamendmentcenter.com/path to liberty. Let me get to my notes here. So this is a great way of summing things up. Mike Meharry, an article that we published this morning, he said, if you're hoping recent high-profile cases of police misconduct will spur federal courts to roll back qualified immunity, you're going to be disappointed. And I am the type of person that I like to find the silver lining in anything and everything, no matter how bad things. I mean, we're living under the largest government, the largest military empire in history. And I'm still always looking for the positives, the cracks in the armor, the foot in the door to advance liberty, because it's our duty. I believe it's our duty to set the foundation. As my friend Jeff Dice said from the Mises Institute at their supporter summit last year, I know they have got another one scheduled for Jekyll Island in a month or two, in October, actually. Jeff gave this speech, and it really resonated with me. He talked about their process over at Mises to basically say, brick by brick, we're setting the foundation for the future. And that's the same type of approach that I like to take here as well. We follow Jefferson's advice, as I mentioned on Monday's show, in a letter to Reverend Charles Clay, and also in a letter to James Madison in 1790 and 1798, respectively. That is, the ground of liberty is to be gained by inches, because it takes a long time to convince people even of things that are best for them. So if you're going to be disappointed if you're relying on federal courts, let's talk about the most recent court case. There's a guy named Officer McClendon from Richland, Mississippi, and there was an issue with a guy named Clarence Jameson. The officer told Jameson he pulled him over because the temporary tag on the vehicle was folded up, probably due to the wind. So he got pulled over for a temporary tag not being properly affixed. And this is in the court documents, so it's been verified. No one denied it. So McClendon lied about why he needed to search the vehicle. He pulled him over. Then he lies to the driver about why he's supposed to search the vehicle. He claimed that he got a phone call reporting 10 kilos of coke in the Mercedes and pressed him 5 times to consent to the search and ultimately deployed a canine. Now, I'm not the type of guy, I know there are people out there who do YouTubes and things like that talking about, am I being detained? There's all kinds of processes that you can do to either slow this down, and maybe this person was doing it in Mississippi, Mr. Jameson. I'm not sure. But in order to not allow them to search your vehicle. But it's a very scary situation, especially when you're talking, again, the largest government in the history of the world in Washington, D.C., which primarily funds and drives the local police state through surveillance, asset forfeiture, the drug war, gun control, and the like, and all the unconstitutional grant programs that go with it. So it's a scary situation. I'm frightened of cops here in Los Angeles for sure. I always joke with my friends when they come visit. I'm like, don't look at them in the eyes because they've got lasers and they will mess with you. They will mess you up for sure. So he lied about why he needed to search the car. The cop tells him, well, I got a call that said there was a bunch of cocaine and, I got to get in there and look around. And 5 different times he pressed him. And I'm assuming the guy was like, what are you talking about? What are you talking about? Because according to the court documents, that call never existed. It was a pure lie. So then the ensuing search, they eventually get to search the car. It lasted an hour and a half and caused significant damage to the car. Police did not find any drugs or contraband in the vehicle. So it's on court record that the stop was made for this tag issue. The guy got pulled over. They damaged the car. I think it was like $4,000 or $5,000 in damage. The guy actually sued to try to get made whole out of this situation. I mean, the time, the stress, the fear, and then, of course, the damage to your vehicle. I mean, think of a time when so many people are out of work by government mandate or being forced out of jobs. And for those of us who are still lucky to continue working, like yours truly, my partner Sarah, and some other people that I know that still have jobs, there's not much money flowing around in the economy because people are being cautious, or they don't have the money to spend, or things are costing more due to federal inflation, that is printing more dollars and causing the prices to go up afterwards. So this is a crazy situation. So here's what the judge had to say about it. U.S. District Court Judge Carlton Reeves wrote a stinging rebuke of this doctrine of qualified immunity before he ended up granting it to Officer Nick McClendon. Here's what Judge Reeves had to say. Quote, "The Constitution says everyone is entitled to equal protection of the law, even at the hands of law enforcement. Over the decades, however, judges have invented a legal doctrine to protect law enforcement officers," and it's not just law enforcement officers, that's just the most high profile, that's where the most violence and damage comes from. But here's the district court judge is saying this is invented by the courts. Over decades, judges have invented a legal doctrine to protect law enforcement officers from having to face any consequences for wrongdoing. The doctrine is called qualified immunity. In real life, it operates like absolute immunity. And in that episode that I mentioned at the beginning here, that is linked or will be linked at 10thamendmentcenter.com/path-to-liberty, I explain how even though there is a chance to actually win in court, in practice, it is almost impossible. Almost impossible. And here from Mike Meharry's report that we published just over the weekend, he says, then the judge proved his own point. This is allowing them, the judge says, in real life, this doctrine operates like almost like absolute immunity. Then the judge proves his own point, letting the Mississippi cop walk away without facing any consequences after an allegedly unwarranted traffic stop and vehicle search that did $4,000 damage to Clarence Jameson's Mercedes. He says this court is required to apply the law as stated by the Supreme Court. In other words, even though this court thought it was unconstitutional, it was manufactured, made up, invented, absolute immunity in practice. He's like, well, it's all wrong. It's terrible. I've taken an oath to the Constitution, but the Constitution says equal protection of the law, but the Supreme Court said something else, so I got to do it anyways. Under that law, the judge wrote, the officer who transformed a short traffic stop into an almost 2-hour life-altering ordeal is entitled to qualified immunity. The officer's motion seeking as much is therefore granted. They know they're going to win. They know they're going to get away with this stuff. And they know that even if they get a lower court to agree that they've done something wrong, or if someone, the people suing get someone to agree, that they're still going to side with the government. Government protects their own. And what we're talking here about is the doctrine of stare decisis. This is the doctrine of applying precedent over the Constitution. Now, in practice, and I did a short video about this late last year in November of 2019. I will link to that in the show notes as well and probably post it on our social media channels in the near future. But basically, the doctrine of stare decisis, which is also invented by the Supreme Court. Now, precedent can be good because then you learn how someone studied a previous issue, and it can be used well. And I've talked about that in various videos and articles on the website. Adhering to precedent can be good because it provides consistency. But the problem with stare decisis is this is really the doctrine of adhering to precedent, sometimes even when it's obvious and clear that the precedent is wrong. It is wrong. It is a violation of the Constitution. It's made on unsound statements and judgments and opinions. It basically means precedent is supreme over the Constitution. It creates an environment, because it's not always adhered to on the Supreme Court level, it creates an environment where these court opinions become more and more political over time. Because if they sometimes overturn precedent and sometimes don't, then they have an out. Well, it was precedent. I had to go with that. And that allows them an escape route to be able to apply their own political viewpoints rather than following the Constitution. Now, when we're talking about stare decisis, we're generally talking about the Supreme Court, but it does affect lower courts as well, district, circuit court, court of appeals, etc. And there was a law paper posted at SSRN. If you really like geeking out, SSRN is good on constitutional issues. Well, you're going to find the opposition, you're going to find good people, but there's a lot of heavy-duty papers, law review papers. And this one from Josh Blackman last summer, Originalism and stare decisis in the lower courts. He sums it up like this. Lower court judges, we're talking about the Supreme Court. Lower court judges do not have this kind of discretion to overturn precedent. It's not even up to them on a political view. Consider a judge on a federal circuit court of appeals. First, she is bound by Supreme Court precedent interpreting the Constitution, regardless of whether those precedents are originalists or not. In other words, it doesn't matter if they follow the Constitution, or in this situation that I'm talking about here, Judge Carlton Reeves, who says, hey, this is totally wrong. This has no foundation in the Constitution. This was made up. It has resulted in absolute immunity for government officials to violate people's rights, but they get it anyways. And that's because of this precedent issue on the lower courts. They're required by a court rule that says you have to apply this. Josh goes further. He says, no matter how wrong a given Supreme Court case is, that precedent must be followed. And second, she is bound by circuit precedent interpreting the Constitution, regardless of whether that precedent is originalist or not. Only an embanked majority can reverse circuit precedent, and those proceedings are quite rare. In other words, a very narrow kind of situation where they are it's just not going to happen. Now, the paper goes into some detail about some approaches that they can basically apply things narrowly, and I don't think enough judges follow this, but the problem really is not that they're just not following Blackman's advice on how to actually reject precedent and still follow the Constitution. The problem is that nothing in Article 3 of the Constitution, nothing in Article 3 of the Constitution at all, or in any other clause of the Constitution for that matter, requires adherence to precedent. It doesn't say in the Supremacy Clause or Article 3 or anywhere else, Bill of Rights, that the Constitution means what the Supreme Court says it means until it changes its mind, and all the lower courts in the country and all the state courts in the country have to follow the Supreme Court opinion until the Supreme Court says otherwise. That is a rule of an oligarchy. That's what Thomas Jefferson warned us about. We know that nothing in Article 3 or any other clause of the Constitution anywhere even delegates a power to the judicial branch to create binding rules like this that require all current and future members of the judiciary to follow their precedent. There's nothing in there. This is also a made-up problem on top of a made-up problem. A made-up legal doctrine added to another made-up legal doctrine means you end up with absolute immunity for government officials. So that's a serious issue there. Here's a case that just happened where even though the judge specifically said, they're violating your rights, this is really problematic, this is made up, but, well, got to go with it. Precedent tells me I have to. It doesn't matter. And, I saw some comments on a Reddit thread somewhere where basically like, hey, it's his job. If he doesn't follow that precedent, it's going to look bad on him. Well, at some point, we got to have people that are willing to stand up for what's right. Find a way to actually point this out beyond just making a publicity statement. You got to do what's right. Even if the next court overturns it, at least kick the can down to somebody else. Do what's right on your end. Lose your job. You're in the wrong job if you can't have a moral standing. If you have to violate morals, if you have to violate the Constitution, you are not in the right position. Quit. Anyways, next situation. One issue is precedent. This is another thing that I thought was interesting over at SCOTUS blog. This was in 2016, again, to precedent. The court issued a summary reversal. This is October of 2016, and it intoned that it is this court's prerogative alone to overrule one of its precedents. The Supreme Court just in 2016 again reaffirmed the viewpoint that only it can overrule its own precedent. So once it takes a position, how is it ever going to get back there? It is almost impossible because everyone has to apply. You don't have a conflict then. If everyone applies or people just say, well, I'm not going to sue now because it's so expensive, the odds of actually getting to the Supreme Court, if they just had an opinion on something 1 or 2 years ago, we know they rejected a bunch of qualified immunity cases recently. So what would be the point? It discourages people from challenging things, and it creates this precedent supremacy over the Constitution itself. The court went on and said those precedents bind lower court whose decision was under review. The summary reversal, and this was by Richard Ree, the summary reversal fits a familiar picture of vertical stare decisis, in which the court issues formal precedents that lower courts are absolutely obliged to follow and absolutely may not overrule. So let's go to the next case. One issue is precedent. The next case, according to court documents, and this is we published this morning. Just this morning. Butler County, Iowa Sheriff's Office Deputy Bruce Tierney kneed a guy named Charles McManamy, I apologize if I get that name wrong, in the face 20 to 30 times. After he was already restrained by 4 other officers, already held down, got kneed in the face 20 to 30 times. Bam! I mean, this is just over the top. It doesn't matter how bad the person is or what they may have done wrong. In the American system, as Thomas Paine once wrote, the law is king, and there is no law that says that a cop or any government agent is judge, jury, and executioner. If their job is to arrest somebody for doing something, and I would make the case that most laws on the books violate the Constitution in the first place, so we should never be cheering on the enforcers of those things, because most of the time what they're doing shouldn't be happening at all. Most of those law enforcement officers, the founders didn't have any publicly funded or government-funded police departments. I think the first one was in like the 1830s in Boston. So the founders didn't have this. We don't necessarily need to have this kind of garbage either. To knee someone in the face 20 to 30 times is just, it's hateful, it's cruel, it's evil. No moral person should ever support this kind of thing. Anyways, I will stop my editorializing there, but I can't avoid that. Anyways, the case goes to the U.S. Court of Appeals, 8th Circuit. The majority of the judges on the panel agreed that that the deputy violated this person's right. We'll call him Charles because I can't get that name right. So the court actually said, okay, you violated his rights. We know this. It is clear. We can see this. So the court can actually agree that they violated the rights. But the suit still failed, and the guy still got the immunity. It's qualified. They call it qualified because you're not guaranteed. It's not absolute immunity. It's not sovereign immunity. It's qualified. You may not get it. There's a chance that the court will say otherwise, but he still got it. It fails for a different reason, the court said. The absence of a clearly established right. A right to, we don't know, it's not clearly established that you don't have a right to not be pummeled in the head and the face 20 times while being restrained. They say he must point to a case that squarely governs the specific facts at issue, Circuit Court Judge David R. Strauss wrote. And what that is, and I talked about that again, these tests on how something qualifies for qualified immunity. In essence, in practice, the way it plays out is that the court will always give this immunity to the government agent unless a previous court has already held that they didn't qualify for that immunity in virtually the exact same scenario. In other words, another court case would have had to have come up where you had almost the same facts. 4 officers holding someone down and someone getting kneed in the face 20 times, 30 times. Maybe it needs to be in the same state. I don't know. I don't know how detailed, but you basically have to have the same situation. So you've got this circular reasoning saying, well, no court has ever told us that this doesn't qualify for immunity, so therefore we can't reject the immunity request. So it ends up always resulting in absolute immunity. And I mentioned in that episode, again, there's a guy named Elon Werman, who had a paper in the Seattle Law Review called Qualified Immunity and Statutory Interpretation. He explained it as erecting an almost insurmountable hurdle to those trying to prove excessive force or a violation of their rights. And this is how it was summed up. The qualified immunity test, this is how the courts apply it, poses an almost insurmountable analytical problem. The permutations are infinite. In any situation, there's a little bit different scenario, and that allows a situation where the courts can say, well, it's not exactly the same as something else, and no other court has said this, so in other words, it's never going to happen. A given situation, he writes, is rarely exactly like another. There will always be sufficient distinguishing facts to decide that there was no clearly established law. So not only do you have the precedent issue, so even if you can get the situation where, okay, well, we've got a situation where we could apply or reject your claim for immunity, and we've seen a previous situation held like that, but, well, precedent tells me that I can't do it. It's got to get kicked up somewhere else in the hopes that you make it to the Supreme Court, which is probably not going to happen. So you're out of luck. Too bad. And then we have this test problem. And then really they kind of are the same type of thing, but they're two cases in two locations from two circuits, a couple of different districts. We've got Mississippi and Iowa, and it's the same end result, where the judges are actually taking the position that the person's rights are being violated, and the person who violates their rights are still immune. So if government can never be held accountable for violating someone's rights, what do you think is going to happen? It doesn't take a really smart person to figure out how dangerous that is. Now, another issue in the first case, the Jameson case, he's sued under two things. One of them is the 14th Amendment. And Mike Meharry points out that, ironically, the 14th Amendment was Jameson's undoing. Were it not for the dubious incorporation doctrine, which was also made up by the Supreme Court based on the 14th Amendment, it purportedly empowers the federal government to apply the Bill of Rights to the states. Without that, this case would never have gone to the Supreme Court. It would never have gone to the federal court system at all, period. And no cases for violations of rights on a state and local level went before federal courts up until the 14th Amendment. It was always rejected. I mean, maybe there were a couple of cases, but they were rejected as saying, well, this is a state issue. So Jameson, in the original situation, would have sued in state court based on Mississippi's Constitution and Bill of Rights. Furthermore, Mike Meharry writes, were it not for the 14th Amendment and the incorporation doctrine, there would be no federal qualified immunity in the first place to shield cops like this from the legal consequences of their actions. And as Denver Libertarian mentioned at the beginning, if you were here right from the beginning, there was a comment about an activity in Colorado. I did an episode on this in July. End qualified immunity from the bottom up. We cannot count on the courts. They've got this precedent. They've got this almost impossible test. So the courts are just, in fact, I would almost say it is worse to go to the courts. I mean, maybe you get lucky. It's almost worse to go to the courts because of the time, the expense. Unless someone is representing you for free, the odds of you being able to go there and recover your $4,000 for the damage to your vehicle, or I mean, if someone's killed or beat up, I mean, there's a principle at hand there. But the odds of you being able to afford this, they count on average people. This is just like with civil asset forfeiture. If you find that they're taking billions of dollars, but the average amount that they're stealing from people is like $500, most people can't spend the thousands and thousands of dollars against an organization that will just print money out of thin air in order to keep going after you. They are relentless in proving their point. So I noted that not only do we have the court issues, but the Congress isn't going to do anything about it. The Imperial Congress is just horrible when it comes to the Constitution. But recently in Colorado, and then also a smaller event in Connecticut, we see legislation that was passed into law to actually change the process where you open the door. Now you can go. It's basically driving things the way the founders wanted it. In Colorado, they've created a law where you're basically driving people towards state court to do these things. And the odds of it actually getting removed to federal court are much lower. So if you're encouraging people to go to the state court, you at least still have a chance. Not that the state courts are really that great either. They're really pretty bad. But if state law now allows this type of thing, despite what the feds say, then you're not suing under the federal constitution. You're now suing under the state constitution. I encourage you to check out that episode from July, End Qualified Immunity from the Bottom Up. We're going to be watching this very closely in the next state legislative session for 2021. We expect a number of states to be considering legislation to chip away at the federal doctrine of qualified immunity going forward. Well, just taking a quick look over at the live chat, I hope you guys are finding this interesting and educational. More important than anything, I hope we are learning something. Chris Chalinsky over on Periscope has a great point. When cops get sued, and this is a big part of this problem too, not only can they just print the money, but they steal it from us in the first place. When cops get sued, do the taxpayers still front the bill for them to retire early? Yeah, without a doubt. Jonathan Boatwright, good to see you, buddy, says thanks. Funky euphemism, I agree with you saying I think the Colorado bill is a net improvement and worth adopting, but yeah, it doesn't reject the federal government's right to handle qualified immunity. I don't know if there really is a way for them to be able to pull that off, but over time, maybe we're going to learn and some smarter people are going to explain to all of us. Aether Dad, here's an interesting point over on YouTube. Find an officer of the court who wants to erode absolute immunity through ruling against qualified immunity. Well, I don't think there really are any. Dan Reed, angering, that's how I find it. It certainly is. I mean, this type of stuff doesn't piss you off. There's not much humanity left. Because even if you're like backing the blue, you're on the thin blue line, I mean, no one should be backing government. Living under the largest government, largest empire in history, there is no part of government that is worth backing. Only when they do something right. And if you take the view that I do, that 90% of laws on the books are violations of the Constitution, either federal or state in the first place, then 90 times out of 100, all the time, with just closing your eyes and while even looking at something, they shouldn't be doing what they're doing. So it's very hard for me to actually back any government agency because they're terrible. And I agree, it's very angry. Denver Libertarian says, I'm writing an article on the Colorado legislation with a rather pessimistic tone. It sounds great in theory, but it won't do much good. And dang it, my presentation is now increasing. I don't know if you've actually checked out that episode where I covered it, but there's also some good insight over at the Volokh conspiracy over at Reason that might have some insight as well. It's really going to really just sees how we're going to have to see how things play out. Basically, what we're looking to do on this is to bypass the federal court system. That doesn't mean it's definitely going to end, because you still have a problem of the state judges being bad, state courts being bad, but now you're talking about going from no chance to having some chance. And the more states that actually take this approach, I think there could be a positive end result for some people. Scott Lashua, I agree as well, over on Facebook. SCOTUS and the rest of them are completely out of touch with reality. Just look at all the cases they've heard, and the actual cases based on rights listed in the Constitution, 10 Second Amendment cases, they simply deny. They're biased, broken, and out of touch. Funky Euphemism says this is all a plenary power of the states. The correction is theirs to make. Oh, that's interesting. That might be partly over my head, Funky, but maybe send me an email and go with a little more detail on that as well. Chris says, needing case law is frustrating because they already enforce mask mandates, but just forgot all about, I think that might be a different... You must show malice. Okay, I'm going to read through the rest of this. There's a lot of back and forth on legalese and things like that. I'll have to check out a little bit later. Maybe some of it you guys know better than I do. And so then I'm going to learn something through the live chat as well. If you enjoyed this show, if you learned something, if it pissed you off, it doesn't matter. If you're still here with me, please consider doing a few things that are totally free, easy, fast, and awesome to help us spread the word. Smash the like button on any platform that allows you to like. Leave a review, comment, all that stuff. 5 stars on iTunes is amazing. 4 stars, 3 stars, whatever. Just leave some feedback. The more that we get that type of feedback on, generally positive is better than negative. But if you really want to tell us something, whatever you got to say. But all this type of thing, all these types of things, they trigger the algorithm of the platform that you watch or listen on, especially the mainstream ones, and it tells those platforms to show the program to more people. And we are continually growing and reaching new people every single week. And of course, if you really want to get behind us, put your financial faith behind our work. I'm very grateful for many members that I see out there in the live chat. that I'm very grateful for. Thank you so much for getting behind us and helping us get the job done. You can support us through our membership program. Join them as well. 10thamendmentcenter.com/members for as little as $2 a month. We also have just a one-time donation if you prefer over at 10thamendmentcenter.com/donate. Again, thank you for joining me today. Thank you for being here, watching, listening. I hope your week is going well. We're on hump day, getting close to the weekend. I'll see you next time on Friday here on the Path to Liberty.